Good afternoon, everyone. My name is Adiola Sumola, and I am a partner in Udo Udoma and Belo-Osagie's Banking and Finance and Compliance and Investigations team. It's my pleasure to welcome our esteemed panelists and the audience to the UUBO Investigations, Compliance and Ethics Virtual Summit 2022. UUBO has created a niche for itself in keeping both clients and connections informed on key regulatory changes, as well as stimulating thought-provoking on contemporary legal issues, compliance and ethics summit. Since 2018, the UUBO Investigations, Compliance and Ethics Summit has been hosted as an annual knowledge sharing session, which we've called the HICE Summit in some instances and the HICE series in other instances. The ICE Summit 2022 is the fourth cycle of the UUBO Compliance and Investigations Practice Teams Annual Summits, and it's scheduled to hold today, 27th, 28th, and 29th of September 2022 as a series of webinars. For this year, our theme is HICE, from trends to remediation. As an interactive forum for knowledge sharing and exchange by professionals, we are excited to host this session on an annual basis. And what we seek to do is to bring together practitioners and professionals across the private and public sectors and discuss issues that are related to investigations, compliance, and ethics. We also feature presentations and do a Q&A session, which is anchored by leading experts in these fields, including several of our partners and our speakers, some of who are currently on the screen. I'm delighted to be moderating the first session of the 2022 series. And this afternoon, I am joined by an esteemed faculty comprising leading investigations practitioners whose work cut across various jurisdictions. It's my pleasure to welcome Olukayode Dada, who is a partner at Belo-Osagie, Sarah Bishop, who's an off-counsel at Covington and Berlin, Nicholas Kiri, who's a senior associate at Slaughter and May, and Sam Eastwood, who's a partner at Mayer Brown. Welcome, Sam, Sarah, Nicholas, and Olukayode, and thank you for joining us today. The session this afternoon will focus on investigations, and we will be discussing the topic, charting a path for effective remedial actions. What we are going to do this afternoon is to discuss how businesses can address failures arising from breaches leading to an investigation, or maybe even sanctions, best practices for implementing remedial actions following an investigation, how to minimize the reoccurrence of the subject matter of the breach, as well as key takeaways from an enforcement action. We'll discuss the importance of remediation refer those questions to the appropriate members of the panelists at the end of our session. To get started, I'd like to invite each of the speakers to do a brief intro and to tell us what they do, which genres you cover, and what of investigation and compliance of respective practices. Can everyone hear me?
We can hear you now, Adiola. I mean, sometimes you break up, but I think what we'll do is we'll make sure that this keeps flowing anyway.
Okay.
So don't worry about that.
Okay. Yes, I said that I invited each speaker to introduce himself, and I'm starting with Sarah.
Thank you. Delighted to be back for my second year speaking at the ICE Summit, and years before that attending and viewing the session. So thank you very much for the invitation. I'm Sarah Bishop. I'm of counsel in the London office of Covington and Burling. I'm a US and a UK qualified lawyer, so my work covers both jurisdictions. And my practice includes white-collar investigations, primarily in anti-corruption, as well as compliance, again, with a focus on anti-corruption compliance, business and human rights, and ESG.
Thank you, Sarah. Sam, you're next.
Yeah, so I'm a London-based partner in Mayer Brand's white-collar crime practice, and I was on a panel last year with Sarah, so this is all looking quite familiar. And my practice is very similar to Sarah, so it's a focus on anti-corruption and an increased focus on business and human rights. I have been a monitor, and I think we're going to talk a little bit about monitorships in this session, and that can bring, I suppose I bring that insight to the discussion. Monitorships can be a really important catalyst for effective remediation. I'm really looking forward to the discussion. I hope it'll be interactive and look forward to it.
Yes, Nicholas. Thank you, Sam.
Hi, everybody, and good afternoon. And thanks, Adiola and team, for the invitation to speak. I'm Nick Carey. I'm a senior associate at Slaughter and May, and like Sarah and Sam, I mean, my practice is primarily investigations focused, dealing with corporate investigations in respect of allegations of bribery and corruption, but also a fair amount of financial services work and other related activity there. And principally, obviously, the jurisdiction that I'm concerned with mostly is the UK, and dealing a lot with our primary economic crime regulator here, the Serious Fraud Office. But owing to the as Sarah and Sam will also, I'm sure, confirm, owing to the typically multi-jurisdictional nature of this kind of work, dealt with cases which overlap with all kinds of jurisdictions, from the US to Western Europe, but also in Nigeria as well. So really looking forward to discussing these topics and also hearing the Nigerian perspective today as well, which I think would be fascinating.
Thank you, Nick. Olukayode.
Thank you, Adiola. My name is Olukayode. I'm a partner in Dodoma and Belo-Osagie in the compliance and investigations team, as well as in the complex commercial litigation team. In terms of compliance and investigations, I focus more on ethics and compliance, anti-corruption, anti-money laundering, and combating the financing of terrorism issues. So in my practice, we, apart from dealing with the local issues that may arise, we provide support to practitioners all around the world, particularly dealing with FCPA, DOJ investigations, as well as investigations by the Serious Fraud Office. I look forward to this session.
Thank you. Olukayode. Can everyone hear me, please?
Yeah.
Okay. Okay. I'd like us to start this afternoon discussing an overview of the current level of enforcement activity in the jurisdictions in which each of you practice. How does the current level of activity compare with what has happened in the past 18 months, for example? What attitude are you seeing from enforcement agencies? What has been the recent trend? I would like Sarah to start by, for example, discussing examples of any DOJ enforcement action, given your experience.
Thank you, Adiola. Yes, I'll speak a little bit to the United States and allow Sam and Nick to weigh in on the position in the UK. I think US enforcement at this stage is well established enough that the guidance DOJ and SEC put out is going to get the attention of companies when it comes to how they design their compliance programs. There's always a lot of analysis that happens around the specific number of resolved enforcement actions in any given year and public investigations that have been opened. In the past couple of years, that's been a little bit lower than some of the prior years, but I think we're now seeing increasing activity. And regardless, we always caution clients not to read too much into slight dips or the ways that enforcement may wax and wane. Really, the investigations and enforcement actions of today are looking at conduct that happened often 5, 6, 7 years ago. So the guidance that is put out, I think it's important to focus on that guidance and incorporate it into your compliance program planning, including in the important area of how you remediate issues identified in investigations. And what I wanted to focus on from the US perspective is just how the stakes and the expectations for effective compliance have steadily increased in the guidance that DOJ in particular puts out. I feel like we say increasing focus on compliance programs every year when we do trends presentations, but that's because there really are developments that reflect a focus on compliance programs year over year. Just to give some examples, in 2 enforcement actions this year under the FCPA, where companies' compliance programs were subject to criticism, we saw compliance monitors imposed. On the other side, there was a company that received a declination, and among other reasons, DOJ cited its, quote, timely and full remediation, including separation from the executive and third-party intermediary company involved in the misconduct, and efforts to enhance its anti-corruption training and compliance program. So the sticks and carrots are really there in terms of what an effective compliance program will get you. Another development from DOJ that's gotten some attention is introducing as part of resolutions a requirement for chief compliance officers to certify under threat of criminal penalty that the compliance program is reasonably designed to detect violations. That's been somewhat controversial. Some in the compliance community think it's punitive. DOJ maintains that's intended to empower compliance professionals. And we're really going to see the level of sophistication at DOJ in terms of how programs are scrutinized continue to evolve. So we've seen some recent hires of compliance counsel and the new head of the fraud section, who each have significant in-house compliance experience. And very timely to be doing this presentation today, we've had another guidance memo from the Deputy Attorney General, Lisa Monaco, highlighting a number of areas of emphasis in corporate enforcement going forward. One piece of that I thought was very interesting as we think about remediation steps in this session was a focus on incentives and executive compensation, which is not itself new, but a really striking emphasis on compensation clawback provisions. So if someone has been involved in misconduct, they're sending a message that terminating that person is not necessarily going to be sufficient. If they've received a significant bonus, they'll be looking for companies to secure rights on paper to clawback compensation. and to really enforce those rights in practice. So an example of a very specific step that DOJ might expect to see, and I think we'll see companies pay attention to that kind of guidance. Thank you.
Thank you, Sarah. Nicholas, can I invite you to comment on this subject as well, particularly as it relates to enforcement actions in the UK?
Of course, and that was a really helpful introduction from Sarah, almost to counterbalance the position in the UK a little, because where from the DOJ it sounds like we have activity and also constructive guidance. I'm afraid to say that in the UK, Sam will feel free to disagree, but I think the assessment is one of an enforcement regime which is slightly moribund. We've got some issues around activity. So the SFO under its current director isn't opening the number of corporate investigations that one might expect to see in this space. And although it's focusing in part on corporate enforcement, it's also dealing with other matters around effectively consumer protection, boiler rooms, those kinds of issues. It's faced a couple of reviews over the last year into its practices, in particular in relation to the collapse of two significant prosecutions. Those reviews have been very critical of the SFO's processes generally, but also in one respect, critical of the SFO's management up to director level specifically. And there's a question mark, I think, around the extent to which the director of the SFO, Lisa Osowski, will remain in post next year. It'll be really interesting, Sam, to hear, and Sarah, to hear your perspectives on that. And so anecdotally, we know that morale is low and activity is low. I mean, there have been some significant wins that the SFO have secured. For example, the Glencore matter, where there was a guilty plea earlier this year, and Glencore awaits sentencing in the UK courts in later this year in November. But really, it's a corporate enforcement regime which is struggling in some respects, one might say. And what will be really interesting, and again to go back to Sarah's remarks, is to see the extent to which either Osowski next year or a new broom will leverage much lauded connections both with the US but with other enforcement agencies around the world to really look for new work and look for new angles where it can use its investigative powers and show and demonstrate that it is a regulator which means business, because there's a big question mark there. I mean, one consequence of this lack of activity and lack of enforcement is also that what we have is an environment in which you're not getting the kind of messages that are useful in cementing cultural and compliance changes in organizations, which you might get if you, for example, were to look at the activity rate in the US. So there's not only the lack of enforcement activity, but also that then bleeds through into what's the guidance that that environment is giving to corporates in terms of maintaining good compliance and cultures in their organizations. I mean, that's obviously the key UK regulator. There's other regulators here in the UK which are doing other interesting things. So HMRC, the revenue is quite active. The UK Financial Conduct Authority is quite active and very relevant if you're a regulated firm, regulated business in the UK and in London. But on a global multi-jurisdictional basis, the key player is the SFO, and I'm afraid that it's not a particularly happy story to tell currently. But Sam, you may have a completely different perspective, and I'm grateful for your views on that topic.
As you were speaking, one of the questions that came to my mind is what's responsible for this current challenge? I don't know whether, Nicholas, you want to comment on that, or if we should hear Sam's thoughts on this issue of enforcement and that question as well.
Just very quickly, and again, Sam may have, I'm sure will have views, and really interested in those. I mean, one issue is intelligence and resourcing. You'll be aware that we're not in an environment of particular surfeit funds flushing around the system in the UK, and law enforcement has had to cut corners or has to cut its budgets, and there's an argument to say that the resourcing of the organisation needs to be better in order to look out there and find the big cases, and also to prosecute them and investigate them successfully. So resourcing is one aspect, but there's also, I think, the question of intelligence gathering and cooperation with other agencies, which previously wasn't perhaps as good as it ought to have been. I think there's been a lot of store placed by the SFO director on building and developing those interagency connections and relationships. And it may be that they bear fruit in the future, but certainly we know that the SFO is going to need better resourcing in order to continue to lay claim to be a premier corporate crime enforcement agency. At least that's this perspective here, that I don't know whether Sam has a different take.
Okay, thank you. So Sam, let's take the discussion to you. What are you seeing in terms of the current level of enforcement activity?
So my US colleagues, and I'm sure Sarah's the same, talk about the surge in the US. I don't think we are seeing a surge in the UK. And Nick has called out the issue of investment. Ultimately, I think it is the case that the SFO has been desperately under-resourced, and I don't think there's any sign that's going to change, and you get out what you put in. So I think resourcing is a key issue, a key constraint. I think another constraint, probably Nick, the SFO would say, is that they don't have the tools to do the job. They would greatly, there certainly is a move within the UK for new legislation. I think what we would say is that the old legislation needs to be better enforced. But I think it is likely, I mean, watch this space, there probably will be new legislation. There may well be an extension of the failure to prevent offence, which does reinforce the importance of compliance. But I suppose, I think I would also counter the sort of rather gloomy outlook so far as UK enforcement is concerned with the fact that UK companies ultimately, I mean, big UK companies have got international interests, and they're just as focused on what the enforcement environment might be in Nigeria, US, Holland, France, and elsewhere. And generally speaking, it is a much more risky environment. And certainly they're very mindful of the guidance that Sarah has called out. And I think I would also say that we're here to talk about investigations, and then following that, remediation. Enforcement can obviously be an important catalyst for investigations, but there are a whole lot of other reasons why there might be investigations. Not least, a good compliance program will beget investigations. If you don't have investigations, you probably don't have a good compliance program. But the other factors might be increased transparency, whistleblowers, the press, and civil society. I think we're seeing across the board, particularly in the human rights world, which Sarah referenced, some really active manoeuvring, positioning, complaints, and litigation brought by civil society, which in turn precipitates investigations. So enforcement is an important part of the piece, but I think there are a whole lot of other reasons why audiences, across the world, and certainly Nigeria, need to take investigations seriously and need to consider how to remediate, which is what we're going to talk about in this session. I would just add one other point, which is we've dealt with the US, we've dealt with the UK. I am really interested in development bank enforcement, and perhaps that takes the subject closer to home in Nigeria. But there is a lot of investment by the World Bank, African Development Bank, Asia Development Bank, particularly post-COVID. And with that investment comes responsibilities, not least in the context of managing that integrity risk. And I think we are seeing an uptick in audits, and we are seeing an uptick in sort of post-project review and enforcement. And that may well be something for the Nigerian audience to reflect on.
Thank you, Sam. Interesting conversation so far. I'll come back to you, Sam, because to start the discussion around why do we even need to remediate. But before I do that, I'd like to ask very briefly to tell us whether he's seeing any enforcement, whether any enforcement actions outside of Nigeria has influenced what's happening in Nigeria. What are your thoughts on this, Olukayode?
Well, it's difficult to say, how much enforcement activity outside the country has influenced enforcement actions by Nigerian regulators. But suffice to say that it's been a busy year in Nigeria in terms of enforcement. Just this year alone, the president signed at least 3 major compliance-related legislations into law. The Money Laundering Act 2022, the Terrorism Prevention and Prohibition Act 2022, and as well as the Process of Crime Recovery and Management Act 2022. Now, what is very interesting about the new Money Laundering Act is that it has now domiciled the special control unit on money laundering that used to be a separate organization is now domiciled within the EFCC. So what that means is that the EFCC now has jurisdiction as far as money laundering reporting is concerned for designated non-financial institutions and professions like jewelers, hotels, legal practitioners, and all of those. Now, the EFCC hasn't really started enforcement action based on the new law as it concerns designated non-financial institutions, but they've embarked on enlightenment campaigns. They recently held meetings with hoteliers and other professions. So in terms of where we've seen so much enforcement activity in the antitrust section sector this year. The FCCPC has been quite busy. From the beginning of the year, there has been a crackdown on online money lenders. And people that are not licensed. In fact, the federal government set up a joint task force made up of the FCCPC, that's the competition agency, as well as NITDA, the data privacy agency, and the ICPC, that is the anti-corruption agency, to essentially investigate online money lenders that are not licensed. And that led to some form of enforcement action or threat of enforcement action against Google and Apple, because the FCCPC wanted Google and Apple to take down all of those apps of money lenders, people that do money lending in Nigeria, and they may not be based in Nigeria, and that do online money lending businesses in Nigeria. So it's been a busy year for the FCCPC.
Thank you, Olukayode. Back to you, Sam. I'd like you to tell us about the importance of remediation. That's the focus of our discussion. It's worth spending time on the importance of the subject. Why do you even remediate in the first place? Why is it critical? If to also share some examples of effective remediation actions, that would be helpful.
Yeah, I think what I'll do is I'll deal with the why, and then maybe Nick and Sarah can deal with how, and I'm very happy to complement that. But in terms of why, I start with stakeholders. It's a hackneyed term, but it's an important term. Expectations of shareholders, bankers, customers, joint venture parties, and all will be that a company that has had issues will address them, and good compliance is seen particularly by the investor community as a good proxy for good governance, and bad compliance costs. So I think I'd start with stakeholder expectations, and a key stakeholder is the regulator or the prosecutor, and ultimately, if you want a settlement, if you want a good settlement, if you want to reduce the sanction, then you need to demonstrate as a company that you have identified the problem and that you are at least on a journey, or you have a plan to remediate. So stakeholder expectations, regulatory expectations. I mean, linked to regulatory expectations, and I reference monitorships, but I think there is some merit in monitors, but nevertheless, companies would want to avoid the cost and the burden and the intrusion of a monitor, and actually ultimately demonstrating to the regulator that you are already addressing remediation can limit the scope for monitorships being imposed. And the final point, and Sarah may pick up on this, I really like the word recidivism, but ultimately repeat offenders. The prosecutors don't like that. So ultimately, I mean, to be exposed once, one can address, but if there is a pattern of misconduct, then gone are your chances of satisfactory resolution. You're opening up the possibility of monitorships, and your stakeholders will get really concerned. So maybe I could end with recidivism, but the real challenge is how, and Nick and Sarah will provide some illumination.
Thank you. Sarah?
Thank you. So to do effective remediation, you really have to start with root cause analysis. So the idea of doing a root cause analysis is not new. There are industries and contexts where that's been done for many, many years. For example, in the health and safety context or manufacturing, and I think life sciences companies have had the practice for quite a while. But we saw root cause analysis sort of enter the white collar compliance lexicon about 5 years ago now. It first appeared in 2017 in DOJ's evaluation of corporate compliance programs. And we've seen successive iterations of guidance continue to expand and focus on that idea. And there are a few different established methodologies for doing a root cause analysis. The one I like is called the 5 whys method. I like it because it's very simple and intuitive. You just keep asking why over and over again. It doesn't have to be 5 times, that's just the title. So just to walk through what that might look like, I started mapping out a simple example. So suppose you find in your investigation that a third-party business partner was hired that had been implicated in allegations of corruption in the past, maybe had some political connections, and you find that that third party has been paying bribes. So you might start with, why? Why did that third party get hired? Is it that the company doesn't have a strong enough due diligence process? Is it that you have a good due diligence process, but your employee didn't understand when or how to apply it? Or did you have a due diligence process that an employee understood, but you had an employee who decided to find a way to circumvent the process? And each of those is going to lead you to different follow-up questions and different actions, what to do. Let's suppose we've got the employee who found a way to circumvent the process. So a reflexive reaction as part of the investigation might be bad employee, bad third party. Let's terminate both, the end. The difference in a root cause analysis is now you're going to ask why again. So why did the employee circumvent the process? Is there a culture problem? Is there a management oversight problem? Or we're still management encouraging people to look the other way with questionable business partners? Is there a bonus system that had that employee so focused on just meeting an immediate target that he was willing to find a workaround in the system? You might also be asking, why did my financial or procurement systems allow this to happen? Is there a gap? Is there a control that's missing? If there's a control that's missing, why is it missing? Do we have a resource issue? And you just keep asking over and over again why things have happened. Now, companies look inward and that makes sense, but sometimes one of the questions might be, why did the third party pay the bribe? Is the third party, did we not communicate the expectations? Did we not get a contractual commitment? Are there outside factors or pressures that are making it impossible for that business partner to do the job that you've requested? And is there anything you can change about the way the business is done to address that? And finally, when you start to identify those deeper, broader root causes, thinking about, okay, so this is happening in this country or business unit. Do I have the same problem anywhere else? So it's really like pulling a thread, but the remediation actions have to be customized to what went wrong at the surface level and then at that deeper root cause level.
Thank you, Sarah. I like what you said about, the impact of employee conduct in all of this. And, my next question to Nicholas is really on that subject of employee conduct. But I don't know if, Nicholas, you have thoughts to share on why there is a need to remediate before we talk about employee conduct. Do you want to share those thoughts first?
So why remediate? I mean, for the reasons that Sam and Sarah have identified, I mean, I think there are two, as I see it, pillars. There's the corporate's own internal governance structures. So we've seen a lot more discussion around ESG over the last couple of years, of course, and consistent with good governance, the G in ESG is the principle that if you identify a problem, you remediate, you work it out, you deal with it. Now, there's in a sense, a moral and good corporate citizenship driver there, but there's also, and we've seen it in other instances, there's also, frankly, a commercial driver. We've seen in our practice, and I'm sure Sam and Sarah have seen the same, a real growth in damages claims brought by individuals who are affected, and oftentimes by things that have gone wrong in businesses around the supply chain, around working practices. And so understanding why problems have happened and then taking steps to remediate them can, to a certain extent, also insulate you from that kind of exposure on a forward-looking basis. So that's one pillar, ESG, and then pillar two, obviously, is you may be the subject of intense regulatory scrutiny by an enforcement agency, or if you're a regulated agency, or by your day-to-day regulator as part of their supervisory function. So in those instances, you're going to be having tough conversations with your regulator, with the agency, about what steps you've taken to fix the problem, which gave rise perhaps to loss for your customers or amounted to a breach of some law somewhere in the world. So those I think, I mean, they chime, I think, with what Sam and Sarah have said, but those I think are the two key sort of pillars of why you would want to remediate.
Okay.
But
Thanks.
But on employees, I mean, this is something we've been doing quite a lot of work on for various different clients. It's a really fascinating topic, partly because it throws into sharp relief the interaction between concepts of law. So what are the legal tests you need to apply? What are the regimes you're in? How does, for example, Nigerian employment law become relevant in this context? Have you got overseas secondees, so people who are operating, for example, in Nigeria, Tanzania, wherever it might be, who nonetheless are governed and subject to different employment regimes? And so, you know, what are the right legal tests that you need to apply? There's obviously the factual aspect. So how do you properly identify and work out what employees have been doing for the purposes of undertaking this remediation work, so you can identify who is culpable and who is deserving, if I can use that word, of a disciplinary process, but equally who needs more training, who needs more support. And related to that, you've also got the HR and sort of the softer side, which is you guys are running a business, you have duties of care to your employees, you also want to create an environment which is supportive and fair for everybody. And how you deal with and accommodate these different interests is a really fascinating aspect of the sort of the employee remediation story. And what we've found really helpful in these instances is, so you've done in a sense the 5, 15, 25 whys that Sarah referred to, and you've come to a point in time where you have before you what you think the understanding of the facts is, and then you look at the employees who are with you, and perhaps also some of the employees who aren't with you. And Sarah made a really good point about clawback and the interest that regulators have in relation to that kind of ex post facto control over your employees. And I think there was Ken Polite, I think he made a speech recently, didn't he, Sarah, which he was again reiterating those ideas of employee accountability even after the point in time that they leave the business. So you've got these issues that you're considering, and what we found really helpful is to convene stakeholders from throughout the business, including legal, but also including HR and commercial people, so you have that breadth of experience, to undertake a culpability assessment of relevant employees, and to, as I say, identify and triage those who have to go through that formal disciplinary process and those who need the help and support to perform better and in a more compliant way in the future. I mean, obviously there are other overlapping and sometimes additionally complicated aspects of this employee remediation process. So when you're dealing with just one regulator, say the SFO, then that might be tricky enough. If you have overlapping regulators who will also take an interest, for example, in fitness and propriety of your employees, that can again also create a further aspect of complexity. So if you need to speak to here, it would be the FCA, the SEC, etc., around the suitability of individuals who you are dealing with. Also have to remember as well, further really interesting part of the puzzle sometimes is that you may be dealing with people who themselves are under investigation currently. You might have resolved, but the investigation into individuals can continue. And how do you implement that remediation program? How do you work out who did what and what outcomes are appropriate in circumstances where the individual concerned may say, okay, this really isn't fair to me because everything that I say to you is going to go to the SFO, it's going to go, for example, in Nigeria to the EFCC. And so I can't meaningfully and usefully participate in this process. And we've seen instances where individuals, because of restrictions placed on our ability to deal with individuals who have been implicated in certain conduct, they've been on suspension for 1, 2, 3 years pending the outcome of these investigations and remediation programs. And how, again, from an HR and employee comms perspective, do you make sure that you keep them on board and do the right thing to them whilst at the same time navigating your responsibilities to regulators? And I think a final point I just make on this topic is the way in which corporates and businesses deal with their employees does have a cultural dimension. And I know, Sam, you've done a lot of work in the Nordic markets, and one of my current clients is based there. And navigating and reconciling expectations of the kind that we've seen handed down by DOJ in recent communications around being tough with your employees and being tough with ex-employees when they've been identified as having been culpable for misconduct, and navigating that and balancing that with the cultural sensitivities of a particular jurisdiction, the way in which things are done with employees, again, is really fascinating. So it's a really complex and bespoke environment in which to operate, but it's a really critical part of the remediation program. Who did what, who needs to face consequences, but also, I think even more importantly, for those that remain, who needs to have further support, guidance, training in order to help them be their best at work.
Okay, thank you. And you spoke about how to ensure that there's fairness while still maintaining discipline amongst employees. it'll be interesting to hear from any one of you actually how you've seen this play out in terms of achieving a balance between fairness, business continuity, and employee discipline. What's your experience around that?
So maybe I can chip in. I mean,
Sure.
No easy answers is the answer, and I think that I mean, I think sometimes it's difficult to reconcile regulatory expectations with cultural norms, and I can think of at least one Nordic company that did receive criticism from the from the DOJ for their failure to take on employees. I think in terms of culpability analysis, and I really like that expression, Nicholas, it's one that I use as well. It gets harder the more senior you are. Ultimately, the more senior you are as an individual, and certainly at board level, the less discretion, frankly. And one of the issues in the context of any sort of root cause analysis and the whys that Sarah referred to is, I mean, are we dealing with the proverbial bad apple, or is it a bad barrel? And so let me think of an example. I had an investigation. It was for a Nordic company. The issue certainly related to the Chinese market. I interviewed one of a number of salespeople in China. She didn't speak English. And then ultimately I looked at the policy, and the policy was in English, and it was desperately complicated. And she'd never seen that. And she'd never received any training. So where does that go in terms of sort of culpability analysis? So no easy answer. I mean, I think Olu Kayode has a few thoughts on this, and in our sort of previous discussions, we talked about the Nigerian approach to sort of senior management. But I certainly, if you're looking for a settlement in the UK and in the US, I think it'll be very hard for any board member who has had any degree of sort of failure to remain on the board. And I don't know whether Olukiade, you want to pick up on the Nigerian approach, certainly at senior level, senior board level.
Olukiade, you're muted. You're muted.
Apologies. Yes. So, and that's right, Sam. You know, it's quite difficult, you know, if there's a misconduct at that at senior level, particularly if you are a regulated entity, because you then have to deal with the regulator while considering fairness. Sometimes there are regulations that actually require you to discipline the employee. For instance, the Central Bank Administrative Sanctions Regulation considers in determining the culpability of management. You know, the central bank considers the discipline that management has meted out to a particular to a culpable employee. So, for instance, if an employee is found to have misconducted himself, and then the management just simply says, "Go away, go and sin no more," that's likely to put the entire business into trouble, particularly if you're a regulated entity. You're likely to receive more stringent regulatory oversight and penalties under the various rules. So I guess, like you said, you know, there's no hard and fast rule to this. And certainly, the more senior an employee is, the more likely a company will consider a survivor over leniency. You know, for instance, you know, like we've done some, all the investigations we've done, and Angela can testify, usually involve senior employees, and then some of them, where there were those that the employees were found culpable, there were those that were not found culpable. But usually, you know, what we see in Nigeria is that where an internal investigation reveals, establishes on the balance of probability that a senior employee has misconducted himself, typically the companies just want to let them go. You know, they just wanted to let them go, and so as to first for you know, to comply with regulatory requirements, or in some cases just for the reputation of the organization itself.
Thank you, Olukaide. I'd like us to take the discussions to the subject of monitorship now. Monitorship is an important feature of remediation. However, there is a sentiment that enforcement agencies sometimes when to appoint a monitor. I'd like each of you to please share your thoughts on specific instances when you think it's best to appoint a monitor to assist entities in the monitoring of remediation efforts and what a monitor can do to succeed. Specifically, Sarah, I know you did speak about, some guidance notes that the DOJ recently published. We could start with, I think that would be great. What's the impact of those rules on this subject?
Sure. So again, this is an area that's fairly well established in US practice. And I think for that reason, we have clearer guidance than we would have in some other jurisdictions around when a monitor will be appointed. Some components of DOJ already have public selection process documents. The recent Monaco memo says that any division or component of DOJ that does not have such a document needs to either develop one or adopt one of the existing processes. And the memo also distills 10 factors, which are non-exhaustive, but illustrate the considerations that prosecutors will weigh in deciding whether a monitor is needed. So perhaps unsurprisingly, given what a monitorship is and does, the vast majority of the 10 factors relate to the strength of the company's compliance program as measured in a few different ways. There's a specific nod to remediation in the guidance. And one of the factors is whether the corporation took adequate investigative or remedial measures to address the underlying criminal conduct, including where appropriate, termination of business relationships and practices that contributed to the conduct, discipline or termination of personnel involved, including with respect to those with supervisory, management, or oversight responsibilities, which tends to be a more difficult area in which to do that culpability analysis that Nicholas talked about. So they are largely focused on the compliance program, also culture, whether the company faces a particularly heightened risk environment. So they're really, and then the voluntary reporting, they're always trying to extend carrots to companies that self-disclose. And so that is one of the considerations as well. The guidance in the memo also talks about some key processes for how a monitor will be selected, with a focus on consistent, predictable, and transparent processes. Also, a requirement to include ethics professionals in the selection process to rule out conflicts of interest. So a monitorship instruction is a very lucrative, interesting, and career-enhancing instruction. So compliance professionals really compete for those jobs. So they want to make sure the process is fair and the monitorships are not going to friends of the members of the committee involved in the process. And I was very happy to see a reference to the selection process incorporating diversity and inclusion considerations. A criticism in the past is that perhaps those jobs have not gone to the most diverse candidates, and we're seeing real improvement there. So DOJ really has made an effort, and the Deputy Attorney General has, to try to make the guidance as clear and detailed as possible, while recognizing that every case is going to turn, of course, on its facts and circumstances.
Thanks, Sarah. Nicholas, do you want to go next? by sharing your thoughts.
Sure. I mean, I think, as ever in this space, where the US leads, the UK in particular follows. And I mean, anecdotally, we've seen greater attempts by the SFO to look to monitorship or some equivalent process, whether it's ongoing compliance obligations under a deferred prosecution agreement and the SFO's superintendence of those. But the position in the UK is that the use of monitors in this, and we're talking really here about anti-bribery and corruption space in particular, is relatively immature, and it will be interesting to see how, particularly in the corporate enforcement actions to come, how the SFO chooses to use and impose monitorships, because certainly they're an important, or will be an important part of their regulatory and enforcement toolkit. I mean, I suppose the more substantive comment is that in other instances outside the UK and with other businesses that we've been working with who have been subject to monitorships or equivalent regimes, this is a really intensive and complex and expensive process and needs to be treated very seriously. But I suppose one positive that we've seen is that actually I think some organizations, they like having that additional legal compliance. You have to turn a negative into a positive in many instances. You have to say, well, now we've got this firm, these people helping us, let's leverage that to the extent that we can. Let's actually generally use that to drive the kind of compliance improvements that we would want to see. And we have the backing to do that because we have the interest and the oversight of a third party. So although it's a scary word, and we've dealt with lots of enforcement actions where instructions have been, don't have a monitor, let's push back on the monitor for entirely understandable reasons, there is a value that can be derived from that independent oversight. And so we mustn't lose sight of the fact that this can be a useful adjunct to the wider remediation journey that corporates will be going on following this kind of investigation, following the kind of root cause analysis that Sarah was describing earlier.
Thank you. I think the issue of independence and lack of conflict is very important. Sam, you have been a monitor before, so I'd like to invite you to share your thoughts on whether you think that monitorship is an effective tool for remediation.
Yeah, so in short, I think it can be. I think the area is evolving, and we're going to hear from Olukayoda about the Nigerian jurisdiction. I think, look, a company may well be able to demonstrate to the regulator, be they US or UK, that they have cooperated, that they do have a plan to remediate, but the regulator may well be worried whether they actually are able to deliver on that remediation program. I mean, to implement an effective compliance program can take years. It certainly can take significant resources. It certainly requires some hard decisions, not only in connection with employees, but also third parties and jurisdictions. And it certainly requires senior management buy-in. So some level of oversight and challenge by a monitor can be really, really useful. The key, I think, so I would say, having said that, it can be very onerous, it can be very expensive, but increasingly companies do have a say in the appointment. So they will not have the monitor imposed upon them. They will usually have an opportunity to put forward a shortlist, which will then be considered by the regulator. That's really important because chemistry is important. I think if well advised, the company will negotiate a terms of engagement which works for the company, because monitorships are always tailored. They should not be, as it were, it's not they have to reflect the particular context. And Nicholas talked about it being helpful. I think it can be a very collaborative process if well managed. I think it can assist the compliance team in order to get real engagement at senior management level. I think one element I would say is it's really important that the regulators remain involved throughout that monitorship process. So I have had experience both working with the SFO and with the World Bank and African Development Bank. The Development Bank model is one that I think is really interesting. They are very actively involved. They have accompanied me on site visits. We've sat down on the occasion of every report and walked through the report, and they have direct interaction with the company concerned. That's not the model so far as the sort of traditional DOJ model is concerned. But I think it is a model that is worth replicating. So I'd say positive, but Olukayode, let's hear about Nigeria and what's going on there. You know, I think that UUBO should be part of this discussion.
Thank you, Sam. So, and we're having this conversation yesterday that there's no structured monitorship in under Nigerian law. So unlike in the US, for instance, as Sarah had mentioned, where the DOJ just issued a regulation, so there's nothing like that in Nigeria. But I would say that there is some semblance of monitorship, you know, by some regulators, particularly the FCCPC. And for those who don't know, you know, we have so many acronyms in Nigeria: FCCPC, EFCC, ICPC. So the FCCPC is the competition agency. So they seem to be they are more modernized. You know, for instance, as part of their cooperation agreement with an investigation subject, you know, they can impose conditional or unconditional supervision. You know, for instance, just to ensure that you know, you comply they do that as a, should I say now, as a bargain for a limited penalty or for waiving penalty. So you have to go back to them to say, we are complying. So that is some form of monitorship, I think, Sarah. So, but in terms of in the financial sector, it's difficult to say that the CBN, for instance, and the SEC, you know, the approach they have mostly adopted is quite different, you know, and I think that it is probably time Nigerian regulators began to consider monitorship as a way of as a corrective measure, rather than throwing a baby out with bathwater just because it has an injury on its left arm. So what the CBN does, you know, instead of this monitorship thing, for instance, or what they've done is to remove the entire board. And a case in point was the First Bank issue last year, 2021, when CBN sacked all the directors of First Bank and First Bank Holdings and reinstated the MD. So while you can say there is a monitorship in some aspects, you know, for instance, you can have sometimes the EFCC, that is the Financial Crimes Agency, while conducting investigation may enter some form of, under the Administration of Criminal Justice Act, may enter some form of plea bargaining agreement with an organization and say, well, if you agree to refund this, we are not going to prosecute you. And then they monitor how you do the restitution. So maybe that is some form of monitorship, but you know, there is no structured formal monitorship under Nigerian law.
Okay, thank you, Oluka. I would like us to go to the Q&A session. I have some questions there, which I will refer accordingly. There's a question here that says, who should take responsibility for remediation, internal audits or the relevant team? Sam, would you like to take that question?
Oh, I'm pleased you've asked me. So the easy answer, I mean, it's the board, isn't it? I mean, it's responsibility at a very senior level, but the sort of secondary answer is that they should be sure to engage all relevant functions. And the person asking the question referred to internal audit, really important. I think they're an undervalued function within the company. They can play a really important part in reinforcing the compliance structure. So it's certainly the board. Responsibility keyword, because in any compliance program, you want to make sure that responsibilities are allocated, are recognized, and are followed through. So thank you for the question. I'm sure others have got follow-up responses, but important.
So the board takes responsibility, even though there'll be some form of delegation, and that delegation may well go to internal audit or other teams within the organization, but it is the board that takes responsibility.
Yeah, I mean, one counter, of course, is that whoever's involved in the remediation has to be independent and ultimately untarnished. So we are looking at individuals who cannot in any way be held to account for the past actions. So that's an important counter.
And typically,
Nicholas?
I was just going to say, typically you would see subcommittees of boards established to take oversight of these issues with, senior non-executive directors, others who will be detached from the day-to-day running of the business to provide that oversight. So you have the independence and the objectivity that's required to investigate, manage relationships with the regulator, if that's part of the piece or the part of the puzzle, and then also oversee the remediation aspects which then follow.
Yeah,
thank you.
I mean, just one further, I agree with that. I mean, the other thing that we've seen in the UK is that some companies will appoint a sort of a quasi-monitor type character in advance of settlement to provide that independence, to provide that challenge, to give an injection into the compliance program, supporting that independent committee.
Okay, thank you. The next question is on lean discussions with regulators. And it says, we hear a lot about leniency discussions with regulators. In practice, is it linked to evidence of remedial actions being taken?
I'm happy to jump in very quickly with my experience at Adiola. I mean, I think
yes, please.
The remediation and compliance story is important when leniency obviously has a specific meaning to some of us in the context of competition investigations, and their leniency oftentimes really relates to how quickly you've come forward with evidence of cartelist activity. But leaving that to one side, if you're talking about leniency in the sense of more favorable or softer treatment by an investigating agency, then remedial actions are key. So they're key in obtaining, for example, the right kind of form of resolution. So in the UK, and Sarah will know this from her experience in the US as well, Sam, demonstrating that you've got a good compliance program in place is usually one way of unlocking, deferred prosecution agreement and more favorable outcome, as opposed to being required to plead guilty to offences in criminal courts, which is obviously preferable. So at the front end, in terms of the resolution, they're beneficial, but also in terms of the back end. So if you're dealing with an entity which is being sentenced, particularly here in the UK courts, and you are determining or negotiating a penalty to be paid, then the extent to which the corporate has remediated and can show evidence of that remediation of developing, then that will be a relevant factor, at least in the UK, for the court and the judge to determine when applying the relevant penalty. So when dealing with regulators, your compliance journey is relevant at every stage, both at the beginning and the end of the investigation.
Thank you. Sarah, would you like to comment on this? In particular, I think it would be helpful if you could share the guidance notes from the D contains any provides on this, on the subject of leniency and whether it's linked to remedial actions being taken.
Yeah, sure. I mean, I agree with everything that Nicholas has said. Of course, under some regimes, you may even be able to benefit from a defense by showing that as a matter of course, you have adequate procedures to prevent bribery under the Bribery Act, for example. In the US, there's no compliance defense, but it is in the guidance and absolutely our experience that showing you have an effective compliance program that is applied in good faith, working in practice, absolutely affects resolution, and you will have a better outcome if you're able to show those things. So normally when you reach the end of the process in terms of the investigations and the fact finding, and you've had those meetings, you'll spend days presenting on your compliance program. And remediation is a really key part of that. It's viewed as a critical element of a well-functioning program. I do have another excerpt here from the evaluation of corporate compliance programs guidance, which lays out specific questions you could expect prosecutors to ask as part of their assessment of penalty and charging decisions. And on the response to investigations, they would ask all the things we've talked about today. Have the company's investigations been used to identify root causes, system vulnerabilities, and accountability lapses? Again, referencing specifically supervisory managers and senior executives. And they'll really dig into the process for doing that, as well as how high up in the company the findings go. So they want to see that senior focus, a thoughtful, rigorous process, and follow through on the remediation, and it will improve enforcement outcomes.
Thank you, Sarah. That's very helpful. The next question here is for Olukayode, but of course, I'll like anyone else to comment if they wish to. It says, to what extent can a law firm be engaged in the investigation of board members of a corporation for any form of misconduct, especially those which have criminal dimension?
Yeah. Adela, before I comment on that, if I may just say one or two things on them on leniency and remediation in Nigeria from Nigerian perspective.
Thank you.
Now, I think that remediation is quite key for an organization, particularly, and that distinguishes that may help in alleviating culpability for the organization. For instance, under Nigerian criminal law, it is deemed that the act of a senior management person in an organization, say a director, binds the company. However, for a junior employee, the act of a junior employee, the criminal act of a junior employee, if done in furtherance of the business of the organization, may not bind that organization if the organization takes remedial action immediately. It depends on when did you learn about it? What did you do? So the evidence of, the remedial action taken by an organization is relevant evidence and may be a good defense to say, we have this compliance program in place that no one should offer bribe. In fact, when we discovered that this so-called employee offered a bribe, we did X, Y, Z and took disciplinary action. So we are not a party to it, even though he did it in furtherance of the business. He just went on a frolic of his own. So, and in fact, in several of the regulations, whether it is the CBN administrative sanctions, whether it is SCCPC administrative penalties regulation, they all speak to what remedial step did the organization take in determining the amount of penalty. What remedial step did the organization take? And finally, there is in 2016, the FCTI court issued a practice direction called sentencing guidelines, modeled after the US sentencing guidelines. Well, except that the US sentencing guidelines deal with corporations, while this deals with all sorts of offenses. So under the FCTI court practice direction, when it comes to charges for corruption and things like that, one of the things the court considers in imposing punishment is whether the accused person paid restitution, and the remedial action taken by the accused company or the accused person in after discovering the Corruption Act. So remediation is quite big in Nigeria. It's something that companies should imbibe. Having said that, no, how can law firms, in fact, there is a, and I was trying to, I can't remember the case right now, and then to answer that question, there was a case in which an employee had gone to court to challenge the internal investigation conducted by a company. In fact, the employee was found, I think it was something about breach of trust and then stealing company's property. So the company then conducted an internal investigation, and the internal investigation established on the basis of probability that that the employee did that act. The employee then went to court to challenge the investigation on the basis that the offense was not proved beyond reasonable doubt because he was accused of an offense. And the court said, no, the internal investigation is a separate process. It's not police or the prosecutor prosecuting you before a court. So how does a law firm help? So a law firm helps. It doesn't matter whether the misconduct also rises to the level of a crime. So, what a law firm does is to help the companies, the company involved. First, you bring in impartiality, you bring in independence, and you bring in expertise. So, where you have an independent law firm conduct an internal investigation, it is very unlikely. It's very unlikely that the employee or the company or those involved will cry foul or will cry that there was bias and everything in the process. So yes, law firms can help companies conduct internal investigations, and whether or not that investigation also is an investigation of a conduct that also rises to the level of a crime. And just before I close, just to say that, and we get these questions a lot from organizations. They say, so after conducting an investigation into a misconduct that also qualifies as a crime under the criminal statutes, they then ask us, do we have a duty, an obligation to now report this to authorities? So the answer to that question is yes and no. I was using no and yes. So it depends. So
I was going to tell you not to ask me.
so it depends. So for instance, if there's there is under the Corrupt and Other Related Offences Act, for instance, there is a mandatory obligation to report a bribery transaction. So that is there. And then under the ISA, that's the Investment Securities Act, depending on the level of the employee involved, you may have to also disclose to the SEC, or if you're a quoted company, you may have to disclose to the NSC. However, there is no general obligation to report a crime. So for instance, if a company conducts an internal investigation in respect of sexual harassment, for instance, which is where we get these questions more, or some nepotism or things like that, or let's just say sexual harassment, which is also a crime under Nigerian law, there is no obligation on the company to report to authorities and say, by the way, we conducted this investigation, we found this person guilty of sexual harassment, we now report. No, that is not required under Nigerian law. I hope I've answered your question.
It was Ugo's question. Yes, I think so. There is a final question here about third parties. It says, in reference to third parties that subcontract other parties in scope of corruption risks, but do not perform due diligence, what other remedial actions would you recommend?
I'm happy.
Sarah, would you like to take that? Yes. Yes, please.
I mean, hopefully this question isn't being looked at only at the remediation stage. So everyone on this webinar will have an advantage I mean, this subcontracting issue is one where you really want to get the communication with the third party and the contract provisions clear at the outset of the relationship so that you don't lose control over who your third party actually is ultimately. So, that would include restrictions on subcontracting. You've mentioned a clause in the contract requiring approval of particular subcontractors, but also imposing obligations on the third party to do the due diligence, to report issues, provide information if requested. And because subcontracting can present a lot of risk, we see clients when they're assessing which third parties to do compliance-focused audits of, looking at that as one of the risk prioritization factors. So is this a third party that is engaged in significant subcontracting? So you can go in, hopefully you have the contractual clauses that say that third party has to flow down all the anti-corruption compliance or compliance with laws, sanctions, and so forth. They need to do their own checks, flow down obligations, and share information with you so you don't lose access to documentation, individuals, what you would need to look at in the event of an investigation. If that all happens, then the remediation should be more straightforward because you have contractual clauses to point to, which also should be tied to robust remedies. So I think this is one where it's really important to make sure you're adequately planning for that possibility in your contracts.
Sarah, sorry, Sarah, I have a question, Adiola, please. Because this question is quite key, and we get this all the time in our practice from clients, particularly clients who are subject to the FCPA. Now, a quick question. Now, does it make any difference when it comes to subcontracting that, or when it comes to engaging independent contractors, that these independent contractors are sophisticated contractors who deal? Let me give you a good example. Say you are a US company operating in Nigeria, for instance, and then you want to engage, say, a human resources company, well established, that does human resources and everything, and you simply just have a contract with this company, include an anti-corruption clause and the relevant clauses in the contract, and then you move on. Then this contractor, that doesn't work for you, then decides to engage in some bribery transactions in respect of the employees engaged on your behalf. Now, to what extent is it a defense that you have no control over the independent contractor? You were not aware of the bribery transaction, you did not sanction it, and all of those things. Is it a defense? And to what extent is it a defense?
Yeah, it depends on the circumstances. So in some cases, that would be a helpful fact. The US authorities often look, for example, to agency theories of liability where they don't have jurisdiction because things perhaps happened outside the United States. So that lack of control would tend to argue against agency. Agency is defined by knowledge and control. But ultimately, the head in the sand answer of I've contracted everything out, it simply doesn't work anymore because we know that most corruption happens through third parties. And we know that just like remediation is an important pillar of an effective compliance program, so are all the steps you take to mitigate corruption risk with third parties. Now, I think there was an interesting factual component in the situation you put forward. You said, what if they are sophisticated companies, right? And you may be able to reasonably rely on the compliance policies and procedures of a contractor. What I've seen some clients do is really due diligence of their processes, if that's the approach you're taking. So I've worked side by side with some clients where we're doing an audit, not of particular facts, but really just to assess the strength of the compliance program that a vendor is applying, where it's a vendor that is high risk because of the services. And you mentioned HR, so we've done this with vendors that are out getting work visas in higher risk countries, for example, and they do a lot of subcontracting. So quite on point to the example I think that you've raised.
Thank you, Sarah.
Thank you. Thank you so
that
much.
aligns with our thoughts, Adiola.
Yes, it does.
Our advice, yeah.
Thank you, Sarah. I would like us to end the session with any for our audience, whom I would like to thank very much for staying with us till the end of today's session. So I'll invite each of you to give one or two takeaways about the subject of remediation. It can be about the types of systems improvements that organizations to be looking to in the context of remediation. I'll start with you, Sam.
Look, very briefly, I think I've said it before, but it's an important message. A company that does not have any investigations, that does not have any problems, probably does not have an effective compliance program. And an effective compliance program requires sort of well-documented procedures for dealing with investigations. And a key part of that is remediation, which is what I've enjoyed talking about over the last hour and a half.
Thank you, Sam. Nicholas?
Just to highlight again, I think the point that we've discussed previously, that when we talk about remediation, we're not talking about a siloed or fixed process following the identification of something which has gone wrong. It's part of a wider compliance journey that all organizations, be they under investigation or otherwise, will want to go on and will want to get management and board support to go on that journey, because it's going to pay dividends in the future.
Thank you.
Was that to me? You cut out for a moment. Well, I'll also
Yes.
come back to something I mentioned earlier. I can't think of anything new, so I think it's a good sign we've covered the key ground. And it's coming back to that root cause analysis. It's something we've worked with a number of clients on in the past few years. And I just highlight that it is separate from the investigation. So we recommend, of course, you can gather facts during your investigation to support it, but we recommend having a separate, structured process that is also written down to show that that is something the company is doing in practice.
Thank you. And finally, Olukayode.
Yeah. So I think for me, remediation is good, but I guess that for some organizations, depending on the seriousness of the infraction, remediation sometimes can be expensive. So I think our advice is to always engage in constant compliance and continuous improvement, in order to avoid the need to remediate an enforcement action. Essentially, an organization doesn't need to wait for a risk event to occur and then begin to scramble to deal with it. So if you test the effectiveness of your compliance program and maybe do some benchmarking, maybe 5 or more times a year, then you can improve on those weaknesses and then avoid the risk event and the scramble that follows. So that's the sort of my takeaway from all of this.
Thank you. And this brings us to a close of today's session. Thank you very much, Sarah, Nicholas, Sam, and Olukayode for starting this year's series with us. It's been great. We've learned a lot. We've talked about monitorship. We've talked about why remediation itself is critical to every organization's compliance program, and we've discussed effective strategies. I'd also like to thank our audience, as I said, for staying with us from start to finish. And I do hope that you all will join us on Wednesday and Thursday for the rest of the webinars. Thank you all.
Thank you so much.
Thank you. And thank you, Adiola.
Thank you. Thank you. And bye-bye.